Hello again, Douglas Rosenthal of the Rosenthal Law Firm with you, sharing with you today a memorandum from the United States Citizenship and Immigration Services, the former INS, a memorandum dated June 25th, 2009, which deals with the religious worker classification, the non-immigrant R1 visa. And I'm going to read from you excerpts which will explain to you the information which is contained in this memorandum. In particular, this memorandum is designed to implement the district court's order in a case known as Ruiz-Diaz against the United States. Now, what was that case about? Essentially, there was a case which challenged the fact that applicants for religious worker visa, in particular those that were filing for a petition for religious workers under the form I-360, could not concurrently, that means at the same time, file an application for adjustment of status, an I-485. And the district court ordered that in fact the immigration regulations should have provided for a I-360 applicant to also file an I-485, an adjustment of status application, at the same time. And now immigration in this memorandum is setting forth the various ways that they are going to implement the court's order. And if you will permit me, pursuant to the district court's order, there were three categories of individuals who will receive protection from the accrual of unlawful presence and from unauthorized work periods during which an individual was not permitted to concurrently file a religious worker form I-360 based application for adjustment of status. What does that mean? That means that if you filed an I-360 before the district court's order, you were not able to file for adjustment of status. And if you couldn't file for adjustment of status, then you couldn't get work authorization, and theoretically, if your status here in the United States expired before you can file for adjustment of status, you would not have been able to get a green card here in the United States. Well, that now is going to change. And here are the three categories. First, any alien who concurrently filed a Form I-360 with a Form I-485 and the I-360 and 485 applications were rejected, now they will have to properly refile the I-360 and I-485 applications with the appropriate fee and the appropriate supporting documentation. They will have any period of unlawful presence and unauthorized employment that began accruing after either the filing of the Form I-360 or November 21st, 2007, that's an important date, whichever is earlier, told until, and here's the magical date, September 9th, 2009. That is 90 days from the date of the district court's order. That is the first category. Again, in summary, if you filed an I-360 and I-485 and it was rejected, you will be able to refile it with appropriate monies and supporting documentation until September 9th, 2009. Anyone who filed an I-360 with the USCIS as of June 11th, 2009 will have any period of unlawful presence and unauthorized employment that began accruing after the filing of the I-360 waived and tolled until September 9th, 2009. And anyone who files a new Form I-360 can now file the I-360 together with the I-485 and will have the unlawful presence and unauthorized employment tolled until September 9th, 2009. Basically, what this is saying is that any alien that believes that he or she is covered by the provisions of the court's order may refile Form I-360 and the 485, the adjustment of status application, with the appropriate fees prior to September 9th, 2009. That's the magic date. I'm going to repeat it again and emphasize it. September 9, 2009. Affected individuals should also submit a copy of the original USCIS denial or rejection notice indicating that the case was denied or rejected solely based on the concurrent filing, which means that if you were denied for some other reason, then you may not be able to take advantage of this section. But if it was only because you filed your I-360 and your I-485, your adjustment of status application, and that was rejected, you can refile on or before September the 9th, until September the 9th. And this is very important for religious workers here in the United States. I cannot tell you how many people this may affect, but if it affects you, please call our office at the Rosenthal Law Firm, 212-625-8300. If you'd like more information, we certainly can help you with this. Remember, our office is 1.5 blocks away from Federal Plaza, the immigration building in downtown Manhattan, at 350 Broadway on the second floor, suite 214. And our telephone number is 212-625-8300. Thanks so much. I wish you all the very best of luck.